Soli, Sorabjee, the former Attorney General at India, Rajeev Chandrashekhar, the Rajya Sabha MP and someone very active on social media, Rentala Chandrashekhar, the president of NASSCOM, and of course Sagarika, Ghose, the consulting editor of the Times of India. Thanks each one of you for being with us. Mr. Sorabjee, I'm going to start with you because you're the legal luminary of sorts here. You have called this verdict the glorious vindication of the freedom of speech and expression. Why exactly do you say that?
Well, the section as it stood with a completely suppressed dissent, different points of view. The section said if any speech caused annoyance to someone, inconvenience to someone. Now what is annoyance? What is the inconvenience? Such vague terms. It will lead to self-censorship. It will lead to chilling effect. So I'm very glad that this section was struck down by the Supreme Court because it would have been really a blot on our statute book. Please understand, freedom of speech is not absolute. Everyone agrees. But the freedom of speech cannot be restricted on grounds like this. It can be restricted on grounds like public order, incitement to violence, contempt of court. These are the grounds, the heads on which can be restricted under the Constitution, but not on the ground that it causes inconvenience to someone. It's such a vague thing. Annoyance to someone. Suppose someone says, I think Shakespeare was a fake. It may cause someone annoyance. So what? You put the machine of Sec66A in motion and arrest the person and send it to jail? Do you have it in any democratic country?
Mr. Chandrashekhar, would you agree with Mr. Sorabjee here? Do you also believe this is a landmark verdict in favor of freedom of speech?
Undoubtedly, this is a landmark judgment. There is no question about that. This is a landmark judgment in more ways than one, because I think on one level we have the freedoms that are enshrined in the Constitution, specifically in Article 19 of the Constitution. And on the other side, we have certain provisions in the IT Act which are connected with some of these articles. And what this judgment does is to completely align the provisions of the IT Act with the freedoms enshrined in the Constitution. So we have seen that the existence of Section 66A, while it may have been well intentioned when it was put in, has had very serious aberrations in implementation on the ground by various agencies who have been implementing it, because at that level the spirit and meaning and intent of the Constitution is perhaps not in view, and therefore I think the removal of this section certainly removes those aberrations.
Rajeev Chandrashekhar, comment on that. You are one of the petitioners in this case. It's a big victory for you as well. But is potential of abuse, that's the primary, concern here, isn't it? Is potential of abuse reason enough to strike down Section 66A?
No, I don't think this was struck down on potential of abuse. I haven't read the full judgment. But the argument my petition made was that the way the law and the section has been crafted, it is completely ultra vires the Constitution, because it is not about abuse. It trespasses. The ambiguity of what it criminalizes therefore causes a consequence that it trespasses into freedom of expression. This is not about potential for abuse. This is the way it has been worded is way too vague, way too general, and creates a definite documented evidence that it will be misused, and it also creates government overreach in the name of security into freedom of expression.
Fair point indeed. Sagarika, I want to get you into this entire debate. At the heart of this entire debate is really the fact that Section 66A gives too much arbitrary powers to the political class. But let me just be the devil's advocate for a minute and put forward an argument that was also put forward in the court. Shouldn't there be some amount of control on the net, especially given how seamless it is, especially given its impact, which in some cases is even bigger than print or television medium?
many have argued that the laws for protection of free speech or protection against hate speech or protection against inflammatory content already exists. You know, there is already Article 153, Section 153, which you can invoke if you feel a particular speech or a particular post offends religious freedom or promotes enmity between communities or incites violence. So you can go to the courts on laws that already exist. The fact is that there needs to be a certain kind of regulation perhaps on all forms of media. I'm not a votary of free speech as license. I'm not a votary of all speech being free speech. I believe certain restrictions have been laid down by Article 19A of the Constitution, which says that you cannot have free speech if it is a question of national sovereignty, public order, decency, and incitement to offense. So the Constitution already lays down certain parameters of free speech. Now, what the court has actually also done in this particular judgment has said that the government does have the right to block websites which are promoting communal hatred, which are promoting violence, which are inciting to violence. So it hasn't taken away the right of the government entirely to act against those websites or those social media platforms which are promoting communal hatred or inciting violence or inciting hatred between communities. It's actually kept that. What it has done is struck down 66A, which was arbitrary and draconian. And as we say, you know, we want to be responsible and free, not irresponsible and censored. That is the nature of the social media regulation that we must move towards.
Mr. Sorabjee, comment on that. You know, the government during the course of this particular case told the Supreme Court that the impact of the internet is much wider and checks on this medium are tougher, and which is why it can be misused. There's also the other problem of anonymity. Aren't these concerns raised by the government legitimate?
No, but I don't think you can restrict freedom of speech depending on the medium. There may be other ways of controlling it. The question is, under the guise of controlling that internet, you will go against people. See what happened? Someone made a cartoon, you know, of a certain chief minister. Chief minister was annoyed. What happened? Man is put in judicial custody. I mean, you can't have laws like that. Where's the question of saying, yes, you have, do it, control it by other means, but not by having such a draconian law? Didn't we get on without it, without 66A? People went to court, they were defamed. There was contempt of court, there were proceedings there. This is a section gives a power to the ordinary police to initiate prosecution, and which lands the person in custody, police custody or judicial custody.
Rajeev, comment on that. Mr. Sorabjee believes there will be responsibility that will come with it, but there is a concern that internet can be misused, and for the reasons that we spoke about. It's anonymous, it has huge impact, it's seamless, it's very quick to transfer information. Don't you think that's a legitimate concern at some level?
No, I completely agree that the concern is legitimate, that the government must have legislation, the government must have rules that prevents the abuse of the internet in many areas. In drug trafficking, in pornography, in inciting communal violence. There are many legitimate fears that arise out of the misuse of the internet. But the way to do it is not to go and upset the apple cart and the balance of freedom of expression in the name of national security. I think there is a better way to do it. These acts and laws must be much more precise, must be consistent with our criminal penal code. You can't have it that you criminalize actions on the internet that are not criminalized with the regular media. That kind of discrimination and dual standard cannot exist. This bill will need to be brought back into Parliament. The government must move fast and create new set of rules that basically addresses the real issue of misuse of internet and does not trespass into freedom of expression.
So, Mr. Chandrashekhar, like Rajeev pointed out, do you believe there's need for regulatory clarity, or do you think there are enough provisions in the Indian Penal Code and in the IT Act that can rein in fringe elements on the internet who may incite violence? What is your view?
I would say that there are provisions which take care of that, or provisions which address that. The question is, do they address that adequately? Do they address that in all situations? This is something for which perhaps time will tell, and we have to really test the limits of those provisions before we can definitively say that everything that the remaining provisions are sufficient to address the issue adequately. But in any case, I think one thing is very clear, that the aberrations when Section 66A was there were certainly much more than any benefit which would have been available in terms of dealing with law and order or public order problems.
Fair enough. But Rajeev, Chandrashekhar, why has the political class been so averse to, scrapping Section 66A? It was in a sense a brainchild of the UPA, so to say. But the NDA also backed this in the court, even though it criticized it while it was in opposition. A government here has given assurances that there will be no misuse. Court, of course, refused to buy that argument. But why does the political class, what is the merit that they see in 66A?
I am not aware. This is one of those million-dollar questions, Andy, because I'm a parliamentarian. I raised this issue in Parliament scores of times. We had a debate in Parliament where the then Minister Kapil Sibal assured us that he will have a public consultation on how to redo 66A. This was an assurance given on the floor of the House. It is only when I found that Parliament, despite many of us in Parliament wanting this to be changed, was not able to do it, that I had to go to court. Because I am a member of Parliament, I am not an NGO, and I have no business being in front of a court. I should be sitting in Parliament and asking for legislative amendments. But it is when the legislative process did not take this into account, despite assurances on the floor of the House, that I had to come to court.
All right, you should have spent your time in Parliament and not in court, but you were forced to. But let's take this discussion forward, and Sagarika, I'm going to throw this to you. It is now welcome what the Supreme Court has ordered today, but given the spirit of the order, should the government now review a host of its controversial decisions, banning of books, banning movies, and what not actually?
We must put this also into context, because remember when 66A was inserted by the UPA government, the then Gujarat Chief Minister Narendra Modi, who is now the Prime Minister, had been vociferously against 66A. He had actually, in fact, even made his Twitter display picture an opposition to Section 66A. Now the very same government of Mr. Narendra Modi was actually arguing in favor of 66A in the court and saying that 66A should remain because we needed to protect against religious incitement and religious hatred. So the government of the day did a somersault. Having said that, as you rightly point out, we have to look at the broader context in which free speech is operating in India today. What happened to Priya Pillai, who was not allowed to board a plane because she was going to London to voice her views on certain development projects? What has happened to Wendy Doniger's book, The Hindus? What has happened to the screening of India's Daughter, that documentary? What has happened to the numerous plays and books that have been banned? What has happened to the fact that certain cuss words are being sought to be banned by the censor board? What has happened to the fact that a social media AIB roast has been pulled off the social media platform? So, on the one hand, if we are going to pursue the line of freedom of speech and uphold the freedom of speech, we have to recognize it is severely imperiled in India today. Any fringe group can get up and ask for a ban, and that ban is put on. The government refuses to stand up to those fringe groups who are asking for bans, who are asking for things to be prohibited, who are asking for things to be taken off the air or taken off the shelves, or people who are not allowed to travel. So I think this has to start a process of introspection about free speech as it is in India today, and whether or not this government is being able to protect free speech, or is it actually hostage to any fringe group that is standing up and calling for bans and prohibitions of every kind?
Mr. Sorabjee, given the huge polarization one is indeed seeing gather pace in India, and it's an extreme climate of intolerance where dissent is almost treason, do you believe the Supreme Court has also delivered a very strong message to the government, to the political class, that no amount of clamp down on the freedom of speech or expression will be tolerated? It is absolutely unacceptable in India. Is that the message that the courts have also intended to deliver?
Yes, you're right. But by the way, don't misunderstand the judgment to say that anyone can say anything. There's no clamp down. You cannot misuse your freedom of speech if it leads to consequences mentioned in the Article 19.2. For example, if it affects public order, if it leads to incitement to violence, various other things. Those are provisions of the Indian Penal Code. The court has not given a license to anyone to libel and abuse. It has merely pointed out that the provisions are so vague, they are so subjective, they are so nebulous, that not a question of possibility of misuse, but the misuse, as I said, inherent in the section itself. So the section had to be struck down in its entirety, it couldn't be severed.
All right, it's not unbridled freedom, and freedom does come with responsibility. I buy your point there, but Sagarika, what do you believe? There is a lot of intolerance in India today that's gathering pace. Do you believe today's judgment will help restore sanity to a certain extent, will help cut down on that intolerance level?
I think it will have some effect, Supriya. I think it should have some effect. I think that the fact that the court has held so heavily that, in fact, you cannot have a section that gives these draconian powers to the government, that gives these powers to the government to clamp down on freedom of speech. You cannot have this, and it must be erased. The word that the court has used is that it has to be erased. So I think this will send a signal to the government. Remember, the Delhi High Court just recently also gave a very landmark judgment where it said that the freedom to dissent cannot be called sedition. In the Priya Pillai case, as you know, Priya Pillai, the Greenpeace activist who was prevented from boarding a plane because she was simply going to London to give her views on certain development projects in Madhya Pradesh. In that judgment, the High Court of Delhi held that the freedom of speech or the right to dissent cannot be held as anti-national, cannot be held as seditious. So I think the courts are speaking up in favor of free speech. I think the courts are repeatedly holding that you cannot have free speech constrained by political or by notions of what is anti-national or by notions of what is the correct thing to say. So I think the courts are sending out a very strong signal, and hopefully it will have an impact on the government. But for the moment, as we know, the climate of bans and prohibition and all kinds of restrictions is only growing.
Rajeev, Chandrashekhar, let you have the last word on this. That in this climate of bans and prohibitions, it's the courts which are standing up for free speech and sending a strong signal. Do you believe that a strong message is being sent out to the political class?
No, I think it sends one message that you can't fool with the Constitution. You cannot play around with the Constitution, whatever be your current level of paranoia, whether you're a political class, whether you're a bureaucrat, whether you're in the media, or whether you're a regular citizen. The Constitution is a document that is our rule book. And I think that the message is, don't mess with the Constitution. Build any legislation that you want, that for emerging media, for emerging technologies, but be clear that at the core of it is the right of an individual citizen to freely express his or her view. However painful or however disagreeable you may find it. It is only when that view trespasses into true criminal conduct that that person can be found to be a criminal. Just because you and I find somebody else's view unpalatable should not be the threshold of evidence to consider him or her a criminal. That is what today's strike down says. The government will have to move quickly to create a much more contemporaneous act with laws that are consistent with our liberal democracy to address their genuine issues of the internet being misused.
Well, this is indeed a landmark verdict, and I think our entire panel is in agreement on that. Thanks so much, Rajeev, Sagarika, Mr. Sorabjee and Mr. Chandrashekhar for joining in with that perspective.
Find us on Facebook at facebook.com/ETNow, and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.